Good afternoon. Got two cases on the docket. The first, 1424-00977, Mauerhan, am I pronouncing that correctly?
Yes, sir.
Versus State. Everybody's here, obviously. You want to reserve 3 minutes for rebuttal, is that right?
Yes.
Okay, and then Pawn Texas Inc., the City of Houston, or counsel at least here for that? Great. All right. Well, we'll change out after this argument. Mr. Pritchard.
Good afternoon. May it please the court, Seth Pritchard for Appellant Mauerhan. Our core contention, Your Honors, the evidence is simply insufficient to sustain the conviction, the offensive conviction in this case, and that would be true even before we reach the 38.07 issue. I would submit that even just on the basis, perhaps a more plain vanilla sufficiency analysis, the evidence the state brought, there's not enough here to sustain the offensive conviction for sexual assault. The entirety of the guilt-innocence phase proceedings in this case is contained in Volume 4. And just summarizing broadly, the first 69 pages was just the Ms. Pratt reciting, reviewing this litany of text messages that they had exchanged with emojis and so forth, going back and forth for over a year. I guess in sake of completeness, those are in Volume 7, but basically Volume 4 she's testifying about, and the exhibits are in Volume 7. And I would submit that the complainant does not even reach the actual facts of adducing the evidence that the state would contend that the offense is delineated in the indictment until you reach page 69, and then it's done at page 72. I won't repeat all of it, but just reading some of the highlights here on page 70. This is a direct quote. I was feeling tired and wanted to go to bed. On page 71, I tell him that I would like to stop and that I would like to go to bed. On page 72, Ms. Pratt testified this did not go on for very long. So I would submit that based on the evidence the state provided, never quite got there to show that there was a point at which Ms. Pratt signaled a withdrawal of her consent, and nevertheless that my client continued up to the point that would be sufficient for the jury to conclude that there was evidence from which a rational jury could convict. Getting past that perhaps cursory or high-level view of the evidence, at the trial we have this 38.07 issue, and the text of the statute is very clear that corroboration, quote, of the alleged offense within 1 year after the date on which the offense is alleged to have occurred. And within 1 year is a very specific term. The only case, there's very few cases empirically on which these come up. Usually these outcry cases arise in the situation of minors. There's not a huge number of cases involving adults, and yet the key case, I think the state would agree with me on this, is Martinez from the Court of Criminal Appeals in 2005. There's a lot of history here. I did not know back in 1975, apparently the legislature started to actually change this common law rule and ended up codifying it. So when according to the history of Martinez, when this rule was codified back
Can you slow down a little bit?
I'm sorry, when this rule was codified exactly 50 years ago, the legislature used very precise words, and they used this term within 1 year. And that does not admit to this on or about language that we might eventually see in indictments. Even in the state's brief, they repeatedly say about a year, which is, to be fair, the same thing that Ms. Pratt testified to. She said about a year. And yet, even if we go to, the state does not have to, in any indictment, to my knowledge, have to identify a specific date of the alleged offense, and yet, for their own reasons, they chose to indict here a very specific date, July 30th, 2019. There's 31 days in July. Even viewed in the light most favorable to the state's theory of the case, it cannot be said that this outcry was made not within 1 year, but in fact outside of 1 year.
So the way we would rule in favor of you is to say that it potentially could have been reported on July 31st.
Yes, and not just potentially could have been, that's the only evidence in the record, Justice Boatman. We looked at this in Volume 4 pretty specifically. Ms. Pratt never testified to what day she made a complaint. Even then, the state in their footnote 4 says that, I said the original officer she spoke to was anonymous. I didn't mean it was anonymous. The name of this officer, Faltucci or Fabucci. It's an Italian name. I apologize. It's in the brief. This officer, Faltucci. She doesn't say when. She didn't even know his name at all. It was the last question they asked on page 75 of Volume 4. She doesn't even know when she spoke to him or the name of the person she spoke to. In my brief, I said Officer Ray turned out to be the investigating agent who testified at the trial. She said she had gotten a report from this officer, Santucci. His name was Santucci. We don't have a copy of that report, Judge. They never introduced it. We don't have any testimony from Officer Santucci. Even if one were to assume, for sake of argument, that the report was made to Officer Santucci by July 30th of 2020, we don't know that that suffices for an outcry statement, much less corroboration. You can walk into the police department and say, I need to report a crime. You can walk into a police department and say, I need to report a sexual assault. You can walk into a police department and say many things to an agent, officer as the case may be. Unless that officer testified what was said, I don't think there's evidence, even viewed in the light most favorable to the state's theory of the case, that there was an outcry, a corroborated statement made. And certainly, Justice Boatman, the argument the state makes in the end of their Roman numeral number 1, the idea that these text messages could somehow serve as corroborating evidence, it's impossible. I mean, one of those happened before the alleged assault. So certainly you can't corroborate something before it happens. And moreover, the statute 38.07 specifically says that the corroboration has to be made to one other than the defendant. Every one of these text messages, there was no third party, these weren't group text. Every one of these text messages was simply between Ms. Pratt and my client. So I don't think any way you look at this, you could possibly get to corroboration, at least as that term has been defined and applied in Martinez.
Isn't there evidence that she reported it to family members before the police?
Well, none of those family members testified of guilt innocence, Judge. I mean, certainly that was the object of this 404B
Do they have to?
issue.
Do those family members have to testify of guilt innocence? If there's evidence in the record, and as my recollection is, she told her boyfriend or partner, however she phrased it, who convinced her to tell her family, her father. Her father asked her sisters. She found out about her sisters. They encouraged her to report it to law enforcement. She reported to law enforcement.
Yes, all that is true, Justice Gotthard, and yet, in Ms. Pratt's testimony, she does not give a single day in which any of those things happened. There's not there in the record at all. The state bears the burden on each element. This is an unusual statutory sufficiency analysis. It does come from the statute. That's what Martinez said. And if the state does bear that as a, well, colloquial call here, an element, they bear the burden. They would have to put on some evidence. They ask the questions, what day did you tell sister, so forth? What day did you tell dad this? There's none of that in the record whatsoever. The state simply did not meet their burden in that regard, nor can any more than they can tell us what day the initial report was actually made to this Officer Santucci. The state wanted to rely on that, and they bear the burden as the party coming here. They have to be the ones to bring a family member, or bring at least a text message if they wanted to adduce it through Ms. Pratt, or bring the Officer Santucci, or give us a copy of this report that Officer Santucci gave on to Officer Ray. The government, the state bears a burden here. They did not do that. If I could just turn briefly to the 404B issue, if I could just address error preservation at the outset. The state makes the contention that this was waived. I think the point of any error analysis or objection on an evidentiary basis is not some sort of trick. It's to apprise the district court of why you want some evidence excluded, as the case may be. Here, I mean, this is volume 3, I believe. There was a pretrial hearing where both of the sisters, Ms. Pratt and the other sister, Veronica, testified as to what they would say. This was renewed after Ms. Pratt got off the stand. They took her on voir dire. Mr. Figueroa renewed his objection at that point. Even then, the judge was very specific. She could only testify that she was aware of other sexual contact with Ms. Veronica, and yet Ms. Pratt got on the stand, used the exact word sexual assault. Mr. Figueroa objected, and that was overruled.
Objected to hearsay.
Yes, he objected to hearsay, yes. But this was after we'd already just immediately had a whole voir dire hearing on whether or not she could say anything at all under the pentameter of 404B. So it wasn't as though this was just freestanding hearsay. She had not, it was not in her initial testimony. She had concluded her testimony, then the Officer Ray testified, then she was brought back up after this voir dire, and the objection was renewed. So at that point we had a pretrial hearing, which I think on the record the judge said objections would carry forward.
The objection was renewed. The objection was hearsay.
Yes.
Not 404.
Correct. After we just had a whole voir dire hearing on whether or not she was able to deduce any 404B evidence to be able to come in through her at all. So I think under the circumstances, it was pretty clear to the judge what the objection was. We're trying to exclude it. And then when Ms. Pratt testified outside the confines of what the judge had told her or indicated at the end of this voir dire she could testify to, that's when yet another objection was made.
Outside the confines, are you saying that by her saying sexual assault, that phrase sexual assault, that was outside the confines?
Yes, the judge was very specific. I believe it's in the page 90, Judge. I'll pull it for rebuttal if I don't have it in front of me. I think it's on my iPad. But yes, the judge was very clear. Was going to permit Ms. Pratt to say she had heard from the sister about sexual contact, and yet yet in her testimony, what elicited the objection from Mr. Figueroa was where she said sexual assault. That was nevertheless, and then she repeated it after the objection was overruled, but that was not within what was permitted, at least at the end of the voir dire, when the judge allowed this to be adduced at all, after they recalled Ms. Pratt to the stand. Regardless, even if we get past the error preservation, perhaps self-indulgently assume that we did preserve the error, I would disagree with the state's contention that we didn't show any harm. I quoted in my brief both of the prosecutors, both individual prosecutors respectively, referred to the evidence in the 404B that Ms. Pratt adduced after she was recalled to the stand, specifically in their summation. I don't know how you could have more harm. So we had a very marginal case here. He said, she said, he said it happened, he said it didn't, type situation, and yet now we had that there was, at least as the jury heard, a sexual assault of Miss Veronica, but there had been no trial of any assault concerning Miss Veronica.
What about the limiting instruction? How's that affected?
There certainly is, I understand the effect of limiting instructions, and we generally assume that juries can infer that this was for the absence of mistake or accident and so forth, but this was not a case where there had been an affirmative defensive theory of an absence of mistake or accident. So I understand there was a limiting instruction there, but I think even the limiting instruction notwithstanding, that allowed the prosecutors to focus their effort and their energy on trying to say this was, beyond just absence of mistake or accident, but actually a propensity type evidence. And that was how they were able to bridge the chasm between what I would submit as a very marginal or thin case at best and the conviction that they were able to obtain. I see my time is rapidly diminishing, so if there are no other questions, I'll go back my last 15 seconds and I'll find that record site for the rebuttal.
Thank you, Kevin.
Good afternoon, may it please the court. My name is David Rogers. I'm representing the state in this case. This case involves a situation where it is clearly able to be inferred from the record that there was a report within 1 year, because the record from the detective testifying was that the report came in July and that some time passed between the report coming in and it ending up on her desk. The assault occurred on July 30th, so even if the report had come in, it wouldn't have gotten to her desk when at the end of July, early August is when she said she got it. So plus you have the victim testifying that she had told other family members before she reported it to the police. So it's easily inferable from the date of the offense, which is July 30th, that it happened at some point before that. And if that is the case, then her testimony is sufficient alone to prove the sexual assault. And given that she testified that she never consented nor asked for the defendant to digitally penetrate her sexual organ, then that's the ball game as far as the defendant is concerned.
So how do we know that it didn't all happen on July 31st? All those succession of events that you just mentioned?
Like I said, I think you can infer it, and also the only time period between that we know for sure is in Detective Ray's testimony. She testifies that the typical way her police department works is that patrol gets the case initially and then it will get sent to her for follow-up at some later date. So we know that the report took place sometime in July and that she started working on it in late July, and she was working on it until early August. So if she was working on it in late July and it had to take some time to get from patrol to her, then I would believe that that is enough for a logical person and a logical juror to infer Well, I'd say logical person because I'm not sure if this is really a jury issue. 3807 is more of a sufficiency issue for appeal rather than an issue that you have to present to a jury. But a logical person could infer, Justice Boatman, that it did in fact take place at some time before July 30th. And as far as the 404 issue is concerned, I think Justice Hart nailed it, that his objection at trial, in fact, was hearsay. That was the only objection that he made during the whole trial, as far when it came to Veronica's testimony. And he received a limiting instruction, which, as the justices are aware, it's presumed that the jurors followed the limiting instruction unless there's some evidence that shows that they didn't. And defense has not presented, nor is there any evidence in the record that the jury didn't follow the limiting instruction. So at the very least, or at the very best for a defendant, it's harmless error. At the very least, it's not preserved. So I don't think.
So in the pretrial, actually I don't think it was a pretrial hearing, it was a hearing before the complainant was called back to the stand. There was a hearing at that point where the defense objected to her being recalled. Was that objection at that point a 404 objection? And then when it was actually in front of the jury, a hearsay objection? Is there a difference there?
Judge, I believe, I don't have the record in front of me. I don't believe that he explicitly stated that it was a 404 objection when he objected to her coming back up. I think it was more of an objection potentially to hearsay, to having her testify as to what her and her sister talked about, because there is a pending case involving her sister that is still pending in the same court.
Or was the 404 objection to the sister testifying? Because my recollection is the state wanted to call the sister to testify also, which the judge said no to that. Was that the 404 objection? Or was it to the complainant testifying?
Your Honor, I believe that the objection to Veronica's testimony was hearsay and 404, I believe. But again, I don't have the record in front of me. However, the objection to actually what Jessica testified to on the stand was hearsay. And the only thing that she testified to was that she did in fact hear that her sister had essentially also been sexually assaulted by the defendant.
What about the appellant's argument that the context of the hearing demonstrated that it was a 404B objection?
Judge, I'm not sure that you can get there on the context when there is no explicit, I don't recall anywhere in that entire section of the record where 404 was even mentioned. And I'm not sure that you can get an implied ruling on a 404 objection. But even if you could, and even if it was preserved, the defense still doesn't get past the limiting instruction that they requested and that the judge granted and the judge delivered. So even if that were the case, I don't believe you can rule in appellant's favor on this particular issue.
Appellant was saying that the limiting instruction was not exactly on point.
I believe it was the standard 404 limiting instruction. From what I recall, that they have to, if they want to consider extraneous bad acts, they must be able to find them beyond a reasonable doubt. I'm not sure, and defense did not argue, and I'm not sure it is an issue whether or not the simple statement that that Jessica testified that Veronica told her something could prove something beyond a reasonable doubt. But even if it couldn't, it's harmless error because the jury's assumed to have followed the limiting instruction, and therefore, if they couldn't find it beyond a reasonable doubt, they did not consider it in their deliberations. And there's no evidence to the contrary in the record, which is required by case law. And so as far as the other issue I wanted to bring up was if this court were to rule that there is not enough in the record to infer that she made an outcry within 1 year, I would argue that the text messages that were admitted at trial are sufficient corroborating evidence to support a conviction.
Corroborating of what? Because I think their point is that the text messages, which happened, some of them allegedly months earlier than the alleged assault, only corroborate the fact that there were flirtatious text messages.
I do believe that they corroborate the fact that the defendant sought a sexual relationship with his much younger cousin, and that really at no point did she seem to explicitly reciprocate those feelings. And those text messages also explicitly lay out what the victim testified was the basic reasoning, like how he excused his conduct, namely helping her with the kidney stone. There are all these text messages about him offering to help her work out her kidney stone and things like that, and that is what she testified was the excuse that he used to digitally penetrate her, was to help her work out the kidney stone. So I think those text messages corroborate her testimony. Now, that then raises the issue, of course, that is not clearly, in my mind, at all been decided as to what standard of corroboration do you need for a statement under 3807. And I think Martinez, in the body of the paragraph, it's dicta, but it's also dicta in every other case I could find, just states that there has to be some evidence, whether it be the defendant's admissions or other similar evidence like that. And in this case, I would argue that those back up what she is saying. So the combination of those text messages backing up what her story is, they don't directly reflect on the actual act, but I don't think they need to. I think there just needs to be that some evidence. Because I think if you choose to apply the other rule that's in dicta, which would be the accomplice witness rule, you run into this issue that it is almost impossible to ever prove in an adult case, because the state could give you all of the corroborating evidence of sexual activity in the world, but we're never going to be able to give you any evidence that corroborates whether or not she consented other than her own testimony, which is clearly insufficient under 3807 because there wasn't an outcry. And I think that if you look at the Scroggin case, which is one that I cited in my brief, that kind of highlights this issue, because that involved a 15-year-old. Before the 3807 was amended to include 18 and under, it was 14 and under. And they held that evidence showing a romantic relationship between an adult and a 15-year-old was not sufficient to corroborate her statements that she was sexually assaulted. And so I don't think that if that was I don't think that can possibly be the standard, because it would basically make it impossible for the state to prove their cases. And under the sum evidence standard, I believe that those text messages sufficiently corroborate her testimony. And so I believe that that would render the evidence sufficient in this case to convict the appellant. I'm out of stuff to say, so if there are no further questions, I'm fine yielding the rest of my time. Thank you.
All right, thank you, Councilman. Rebuttal?
I think I heard 3 times my friend the opposing counsel said the words back up. These text messages back up the state's theory of the case and the theory of the assault. The problem is just quite simply temporal. They were all written before the assault happened. I don't think it's possible to back up an assault before it has ever happened. Even if such a thing were somehow metaphysically possible, we still have the fact that not one of those text messages says a word about an assault. Suggested otherwise, talk about drinking moonshine. They talk about.
What about the kidney stone, though? There are text messages that talk about, I'll show you how to get rid of the kidney stone. That's at least within a day or so of this happening, right?
Yes, by all, I don't think anyone disagrees. Judge Hart, by all accounts, Ms. Pratt had kidney stones, young woman to have kidney stones, but she had them regardless. And there are many home remedies. Someone can find them on the internet or anyplace else where one would find how to handle a kidney stone. I don't think those messages are probative of anything other than someone was looking for a home remedy to handle a kidney stone. And I understand they're very painful, but I don't know how one says evidence of treating home remedy or otherwise a kidney stone is somehow probative of a sexual assault. I mean, the two have nothing to do with each other. I understand that's how she came to be there that night, but she had spent the night at his house many, many, many times. There were also messages about Nerf battles and tickle contests and so forth. I don't think any of those at all are corroborative of a sexual assault, despite of any point in time in which they happened. I heard the prosecutor say he gave a litany of such as admissions, such as scientific, well, they don't have any admissions. They don't have any scientific evidence. They have no evidence of this whatsoever. I think they would agree, at least at the time of trial, their entire statement was a he said, she said, and she chose to do it on a she said. But this would be the first case in history, I've never found one, that allows you to corroborate something before it happens. And to the structure of 3807, Judge, I think what they're asking you to do is find that a victim can corroborate themselves. That's part of the question you were asking me earlier about the total family. Well, unless the family comes along and says, yes, I was told this on this day, or at least I was told this at all, we have no documentary evidence such as emails or text messages to the family. You have nothing more than, I would say it's insufficient, than Ms. Pratt's testimony that she told these relatives. But I mean, if you're allowed to corroborate your own testimony in a statute that specifically says you have to tell another other than the defendant, then no defendant would ever be able to avail themselves of this statute, which Martinez said is a defendant protecting statute, because you're in the position of saying, I hereby corroborate myself. It's the complete opposite of third party corroboration.
I think during the punishment phase, trial counsel tried to keep out the sister testifying using the exact same thing, 3807, and more than a year. And my recollection from the record is that trial counsel said that doesn't apply to the complainant. Does that play into this at all?
I don't think so, Judge, because when we preserve the insufficient evidence objection, like was made at the close of the state's case. That's the argument we're bringing up here on appeal. I don't think there's any case I've ever seen that allows a punishment phase, even if we could call it a concession of counsel, to somehow have an invisible radiation and derogate an objection you timely made to the evidence being sufficient or not. That necessarily has to happen when the state rests and then renewed after the defendant puts on any evidence. I've never seen a case that says any sort, even if we take the state's theory, this is some sort of a harmful concession, I don't think that's sort of allowed to derogate a timely made objection to the sufficiency of the evidence. If that were the case, every prosecutor would now simply put, sort of not just through a punishment phase evidence, they'll look at every appeal, every habeas petition, anything they can that happened later in time, has some invisible radiation to try to go and cure an incredibly harmful error that occurred at the guilt-innocence phase. So I see my time is up, unless you have any further questions for me.
Yes. All right, thank you, Counsel. 14-24-00977 is submitted, and we will change places for the next argument. We're ready when you are.
May it please the court, Charles McFarland for the appellant, Pawn, Texas. I believe the city of Houston has somewhat lost its way, both procedurally and substantively in this case. They've contended that this was somehow a challenge to jurisdictional facts and different in kind than what happened in the court's recently issued opinion in the Martinez versus City of Houston matter, addressing the same project and very similar facts. At the time they submitted their plea to the jurisdiction, they had a different story. So in the plea, the first thing they say is, a similar plea to the jurisdiction was recently presented in oral hearing to the Harris County Civil Court of Law number 2, and said plea contained virtually the same arguments and fact pattern presented in this case. Now, in the briefing they concede that in Martinez it was a challenge to the pleas and not a challenge to the jurisdictional facts. But they say that the appellant in this case has somehow missed the assignment by not producing evidence in response to a challenge to the jurisdictional facts. The case law is clear. Miranda is the best case, but there are many cases that say that for a challenge to the jurisdictional facts, you have to say, okay, number one, you have to challenge the fact. You have to say in your plea, we challenge the existence of this fact or that fact that is essential to the plaintiff's claim.
So what I'm wondering here is is it undisputed that these parking spots were in the city's right of way?
It's undisputed that they weren't.
Weren't.
Yes.
Okay, I thought they weren't in Latinas.
And they're not here.
They're, okay.
I mean, it's incredibly similar facts because they both have head-end parking along Durham, and then the city comes along and they've provided an exhibit, and you know, it's a screenshot in our briefing, a screenshot in their briefing, but you can see what happens is they've curved along the Durham Drive frontage a parking lot that wasn't curved. And so we're getting to the substance of it, but this is exactly what Justice Wilson pointed out in Latinas was you have to look what's happening on the property. If a car comes into the property, that's it. That's where the parking spaces are.
So
There's
who
nothing-
owns this piece of where the parking spots are?
Pawn, Texas.
Up to what point? The curb?
The curb, yes. The blue line, yours isn't blue. Well,
The solid line here?
yeah, the solid, so the driveway, and everything, there's a bike, there's gonna be a bike lane, okay? And the road used to be like this, and now there is, see that driveway?
Right.
The apron's in, that's on theirs. The parking, all the parking spaces are on our property.
Okay.
And you say it's undisputed that the city does not have a right of way to you for those spots?
They're not taking it. I mean, we own it, they're not taking it.
Mm-hmm.
The spaces are there, they're still striped, they now
I see.
back into a curb. So you
Okay.
can't access
I
them.
see.
And because the driveway comes in right to the parking, if you could eliminate all of them, and then you could have a drive aisle to nowhere.
Right.
But the point of that part of the property, and the property is oriented towards Durham Drive, because that's the major boulevard on which the property is situated. That's the main parking field. And it's interesting in the briefing because, and I said that the city has lost its way a little bit, but in the briefing they say maybe those spaces are impacted, maybe they're not. But if they are, there is this other area over here that their engineers identified where that parking lot could restore the function of that parking over here. Well, number one, not for free. And not as desirable of a location. And that's another issue that the court addressed in Latinas and said, not as good. And maybe the fact that there's a spillover lot, maybe that would go to mitigating the damages, but it doesn't go to whether or not there is a taking. So.
Was that holding based on the fact that the flower shop was a quick access place where people would just stop by spontaneously? They mentioned that.
It's mentioned, but I don't think the holding is. I think the holding in Latinas is the grounded portions of that holding are you have to look at how the property is improved. If it's not improved, then you're in a different bucket. You're talking Dahmer, you're talking Santikos. There's lots of ways a raw piece of land can be developed with access. But if you have a developed piece of property, then we need to look on the property, not what do we do in our right of way, or whether or not this is substantive due process, if this is a reasonable exercise of the police power, but how does this affect this property in the manner that it's being used? And the orientation of Latinas is exactly the same. The placement of the parking of the driveway is exactly the same, and calls for the elimination of all those parking spaces. So, two things. To directly address that issue, in the plea to the jurisdiction filed by the city on page 9 in the trial court, it's a little more nuanced, and to be fair, in the interim of filing their plea to the jurisdiction, Latinas came out, and so, and nevertheless they're stuck with a sustained plea to jurisdiction based on the exact same theory that just got reversed by this court. So, pickle. Okay, but they said in their plea, and I think they should be held to their plea in the statements that they make in them, while the construction project eliminates the head-end parking along Durham, ample land exists on the eastern portion of the property for parking as seen on Exhibit B. Exhibit B is the exhibit that they've submitted. Number one, yes, parking can be restored over there, but not for free, and it's not as good. But there's no doubt that parking, and your eyes will tell you that it's been eliminated. But to the procedural point that I was addressing at the beginning, there's no basis for reading this plea and saying, oh yes, they have challenged the jurisdictional facts. There's not a single statement that says, we challenge the jurisdictional facts. The word fact is mentioned 3 times. The first time in that statement I already read that they're relying on a very similar plea, which is Latinas. The second time at the end of the factual statement, they say, with respect to all of the allegations leveled by the plaintiff, the key facts are that none of plaintiff's physical property was taken or acquired by the city. Similarly, no easements or other property rights of the plaintiff were taken or acquired by the city. That's not a they don't challenge the facts. They're not saying these facts don't exist. They're pointing out 2 facts that we agree with, although we don't agree with the import of it. There's an entire column of cases that say that you don't have to have a physical invasion or acquisition of property to be entitled to compensation under the Constitution. And it is a constitutional claim. And then I believe the last time they mentioned the word fact is on the last page of their plea. If there is no question of fact as to the jurisdictional issue, the trial court must rule on the plea of the jurisdiction as a matter of law. Again, they're not identifying a jurisdictional fact that they challenge. And if they did, they didn't do it right because they filed their plea on September 6th and had it submitted without oral hearing, without an opportunity to present evidence on September 19th. We requested a hearing at which we could have adduced evidence, but if we're going to have a plea of the jurisdiction that's just on did you plead a claim, which is exactly what happened in Latinas, and most of this is verbatim from Latinas, that's simply on a procedural basis that simply did not happen.
So your position is that the facts are undisputed here and we just need to decide the...
Well, I do think the facts are largely undisputed, but to the extent that they're not, you have to assume that the facts as pled are true. They'll have another opportunity to come back and show that they're not true, or that in some way they don't support our claim, but that would have had to have that procedural protection of either a Wood Oil hearing, which is an evidentiary hearing, or a motion for summary judgment, which is what Justice Christopher noted in her concurring opinion in Latinas, but not what happened here.
Did you request a hearing?
We did.
Okay.
And that's in the record.
Okay.
But it was a visiting judge, it was on the submission docket, and it just bang, and so much bang bang that they didn't let anybody know, and we had to do whatever the process is when you didn't get notice of a judgment, you have to revive your ability to appeal. So I intended to address some substantive issues. There are some substantive issues, some flaws with their arguments. I expect that counsel will address them, and I'll have a chance to rebut in my reserved time.
All right. Thank you, counsel.
May it please the court. The Texas Supreme Court's jurisprudence on takings going back decades strikes a very delicate balance between the need for government entities to conduct public projects against the very sacred right of private citizens and businesses to hold private property. That's a given. And a foundation of that balance is the idea that all sides need predictability. We need to know what the standards are. And the government entities need to know what the standards are so that they can conduct projects. As Justice Hecht said in the State v. Schmidt case, if a government entity had to pay every property owner down the road anytime they wanted to change a road, nothing would ever get done, and that's just not practical. In this case, the appellant Pawn Texas seeks to blur those lines and improperly shift that balance to say, if a property owner loses a parking space, then you have to pay him for a taking, and that's just simply not Texas law. In this case, we're asking this court to affirm the trial court's judgment for 3 reasons. Number one, Pawn Texas, the appellant, failed to provide evidence showing a fact issue of improper denial of access that would have defeated the plea to jurisdiction. Number two, the Supreme Court of Texas precedent on access-based challenges is very clear and has no application to the facts before you. And finally, the Latinas opinion from this court that both counsel are quite familiar is distinguishable from the present case for very important reasons. First of all, Houston properly challenged Pawn Texas pleading, the jurisdictional facts underlying that pleading. The Miranda standard, which we're all very familiar, is quite simple. That when a pleaded jurisdiction challenges jurisdictional facts, it implicates the merits of the plaintiff's cause of action, and the proponent includes evidence. The trial court reviews the relevant evidence to determine if a fact issue exists.
So what are the disputed jurisdictional facts here?
Glad you asked. In this case, Pawn Texas alleged a claim based on material and substantial loss of access. That's in their pleading in the record on page 8. They did this on several bases, including, as they said, and I'm quoting, as shown on the schematic drawings of the project. The result of this project is a configuration of the property's access and parking that conflicts with the property's use and improvements. That's in the record at page 7. They also talk about how the property cannot function with just the 8 remaining parking spaces along 19th Street. And to restore functionality of the site, the plaintiff would have to construct a new parking area and move the entrance. That's in the record at page 7. They also say that the project has impaired their access to Durham Drive, eliminating the head-end parking spaces along the roadway, damaging the market value of this property. That's in the record at page 8. So, first of all, the City of Houston never stipulated to a simple review of the pleadings. That's just simply false. There's nothing in the city's plea to the jurisdiction that says it's a pure pleadings-based plea. And you know that because we attached evidence to the plea to the jurisdiction. Exhibit A, an affidavit from the city engineer, Mr. Klavacek. Exhibit B, the construction and design map referenced by Pawn Texas in their pleading.
So do you dispute the map? We have an undisputed map here, right?
Yes.
Yes. And so do you dispute that a curb blocks access to these parking spots?
We do not. We do not.
So then if the question is just material and whether that impairment is material and substantial, isn't that a question of law?
And we've provided evidence to help the court determine that. And specifically, Mr. Klavacek's affidavit stated that there's ample parking space on the east side of the building to relocate any arguably lost parking spaces.
That seems undisputed also. So it seems to me that the facts are undisputed, but that we just have to decide what the impact of those is.
Here, there was no, so for instance, to respond to where I think you're going, Mr. Klavacek's affidavit and the map demonstrate that there's plenty of parking along West 19th. If that's not enough, there's additional space on the property to relocate any parking that might have been lost across Durham. They allege that that's inadequate. They allege that they would have to change the building. But they offered no proof in response to our plea to the jurisdiction to support any of that. Our map, our affidavit showed that there was plenty of space there on the property with them to work with. It was their burden and their responsibility to provide evidence supporting the allegation that they would have to change the property, that they would have to expend funds. These are all allegations. They did not introduce any evidence to counter that, and therefore they failed to raise a fact issue, and that's going to become really important in a minute when we talk about the Latinas case. They provided no evidence, and so they failed to create a fact issue. Now, there was no hearing, that's true, but look very carefully in the record. It's the supplemental page 4. They don't mention evidence in their request for hearing. They just said, we think these issues are really complex, we'd like to come talk about it. There's no mention at all. The only case that they cite to about this was one in which there was a hearing. It's just Moment v. State. The property owner showed up and said, Your Honor, I have some evidence, and the court said, waved them off, went ahead and entered a decision. The interesting thing about the Momin case is the state won every single legal issue, but in the end the court reversed simply because the trial court denied the offer of evidence. They never extended evidence to the trial court. The thing about a plea to the jurisdiction is, I'm sure this court's aware, they can file evidence at any time. They can attach it to their response, they can attach it as a supplement, they can, at any time at all, up until the last minute, they can file evidence. They never did that. And that's why the court found that there was no fact issue that would preclude granting the plea to the jurisdiction. Now, as I was saying, the other thing is that with regard to the Texas Supreme Court's jurisprudence on takings, there is no authority that suggests the loss of parking constitutes a material and substantial loss of access. The whole entire basis of their cause of action. There's no Texas authority to support that.
Isn't that what we held in Latinus?
I'm sorry, what?
Isn't that what we held in Latinus, the time?
No, and that's a very important point, Your Honor. In fact, so what happened, let's talk about Latinus. So in Latinus, again, same area, same Durham Shepherd corridor, same project, a florist filed a takings claim against the City of Houston. City of Houston filed a plea to the jurisdiction, attaching the engineer's affidavit, attaching the drawing. But in response, Mr. Latinus attached his affidavit saying, I have a floral shop. It's critical to my business that people be able to drive in quick, hop in, grab the flowers, hop back in their cars and drive off. I don't have any, if I lose this parking, the head-in parking along Shepherd or Durham, I have no adequate replacement. He also attached the affidavit of his architect saying if he loses this parking, there's no adequate substitute. His property, the structure would have to be modified or reconstructed. You don't have any of that in this case. And if you read the Latinus case carefully, in his opinion, Justice Wilson relied specifically on this evidence. He says that, that the city had no response to Mr. Latinus' affidavit, had no response to the affidavit from the architect. That created a fact issue.
What about the part that says a taking results in diminution of market value by unreasonably limiting the owner's ability to access its property for its intended use? And we know that this is going to unreasonably limit the access to the parking spots because there's a curb there.
We know that parking will be limited in that particular area, but there was no evidence provided to the trial court to say that a pawn shop doesn't function unless it has front-end parking along Durham Avenue. I don't know anything about the pawn shop business, maybe like a florist that need to have quick in and out, I don't know. But there was no evidence to that fact. In Latinus, you had the affidavit from the flower shop owner saying, this is critical to my business. In this case, we didn't have that. We had nothing. But we had the affidavit from the architect, we had the drawings of the project saying there's plenty of parking along West 19th, and if that's not enough, there's plenty of space here on the east side of the building, and they can live with that. There was no evidence presented to the trial court that this was somehow inadequate, unlike in Latinus. Further, it's very important also in Latinus to look at Chief Justice Christopher's concurrence, where she reminds us there are no cases under Texas law concluding that the loss of a parking space is a loss of access.
That's what the majority holds today.
I'm sorry?
The rest of that sentence is her saying
that's correct.
That's what the majority is holding today.
She also points out the fact that this case was simply, as the one before you today, ruling on a plea to the jurisdiction. And all they're saying was there was evidence sufficient to create a fact issue. That's all that was there. So when you look at the Latinus holding, understand the limited nature of it, all it does is say, in that case, Mr. Latinus offered enough evidence in response to the city's plea to the jurisdiction to create a fact issue that could defeat the plea. So now look back at this case. We offered evidence to challenge their jurisdictional facts in the form of Mr. Lavinka's affidavit in the schematic drawing that shows there's adequate parking along West 19th Street, there's adequate access from both Durham and West 19th Street. If they feel that somehow they need more parking, there is adequate space to the east side of the property. What did they attach to their response? Nothing. There was no evidence that could create a fact issue in response to the evidence that we had presented. That's the Miranda standard. That's pure Miranda right there. And there are no obligations under Miranda to use special language. We are now challenging a fact There's no special requirement about stop signs or signposting or anything like that. You just have to challenge facts and present evidence. We did that. They didn't attach anything in response, therefore there was no basis on which they could create a fact issue, and that's why the trial court granted our plea. Getting back to the Texas Supreme Court's jurisprudence on takings, the unreasonable and material substantial loss of access standard goes all the way back to the 60s in the Waco cases, the Quee, Texland, and Arkenhold, where that was when the Texas Supreme Court developed the standard that it can't just be any loss. It can't just be a little bit of damage. It has to be a material and substantial loss of access. So when you look at that drawing, look at this. Is there a material and substantial loss of access?
Access to what? Their property as a whole, or
to
access
the property,
to the parking
to the
spots?
property. That's what the Texas Supreme Court
To the
jurisprudence
business.
speaks to the business. And in fact, there are a lot of cases where business owners in condemnation cases, inverse condemnation cases, have lost many more points of entry than Pawn, Texas is alleged to have lost here. And the point is it material? Is it substantial? And the other thing, that's important, and Justice Wilson referenced this in the Latinas decision, is that you have to look at an alleged loss of access after the fact. You can't say, well, we had 4 and now we only have 2. You have 2. Is that sufficient? You have 1 point of access that you've always had on West 19th Street. You have 1 point of access on Durham. Is that adequate? And there are multiple cases cited in our briefing where the Texas Supreme Court has said that far less access than that. It's also important to remember that the Texas Supreme Court has been very clear that circuity of travel and asking customers to drive a little out of their way to get to a location is not a compensable taking. They don't dispute that. In fact, they've admitted in their brief that they're not arguing circuity of travel. So that kind of takes that off the table. But the only way that you can even begin to get in the ballpark of what might be a loss of access is that way, thinking about driving the long way around to get to a parking. But the Texas Supreme Court has been very clear in case after case that circuity of travel is not the basis for a compensable taking. But what we see here is that Pawn, Texas is trying to bootstrap this concept of material and substantial loss of access to this issue of parking, and I think that's where maybe you're going, Justice Boatman, is are we talking about access to the property, or are we talking access to parking? And the issue is access to the property. That's what the Texas Supreme Court has consistently talked about in its cases, particularly where, as here, as Mr. Hlavinga's affidavit points out, as the schematic drawing there points out, there are alternative sources of parking. They still have parking along West 19th. They have that extra area along the east side of the property, and there was no evidence provided to the trial court to indicate that any of this was somehow inadequate, improper, unfair, anything that would come close to the Texas Supreme Court standard for a material and substantial impairment, which you have to reach. That is the standard, a material and substantial impairment of access. And I said, there's just no case under Texas law that says somehow a loss of a few parking spaces qualifies as an improper impairment of access. There just isn't any. And this court should decline Pawn, Texas's invitation to be an outlier in that respect. As I said, the hallmark of the Texas Supreme Court's jurisdiction in takings is this balance between public and private interests. It's the only way that cities can have the reliability to be able to conduct public improvements for the public, for the populace, while at the same time safeguarding private rights. So with that, I see my time is up, and we would ask that this court affirm the trial court's judgment in all respects.
Thank you, counsel. Rebuttal?
More than I have time for. May I proceed? So, in the briefing and here today, he cited the concept that if they had to pay for everything, then they couldn't get anything done. That is how the Mann case starts, Pennsylvania Coal versus Mann. And here's how it ends. We are in danger of forgetting that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the change. There are lots of cases. I want to reject it at the ab initio, the concept that the material and substantial impairment of access has somehow supplanted the actual test, which is a intentional act by the government serving a public use that damages property. That's it. The material and substantial impairment of access test is a test for helping courts understand when a governmental act that doesn't look like a physical taking of property is nevertheless compensable. It was cribbed from the New York courts, who have a constitution that doesn't have a provision talking about damaging. So take it with a grain of salt, because I mean, you have Latinas, and we're right under Latinas. We're optically, if you look at it and blur your eyes, you could think you're looking at Latinas. The courts have routinely said, and he says all we have to do is show that you can get to the property. But the Supreme Court, at the beginning of this road on the material and substantial impairment of access test, was the Dupuy case, which the court said it is not enough that Dupuy can get to the system of public roads and the traveling public can get to his building. You have to look at how does it affect the property as it's being used.
So you agree that the question is access to the business, not access to the parking spots?
It's, I reject the notion that a business exists without parking spots. The parking space, a parking lot is an appurtenant improvement to a building. They don't exist without a building, and the building doesn't exist without the parking. So
did you need evidence to say that the parking was really important to the pawn shop?
No, because that's obvious, but Mr. Havlicek, not Mr. Hoflinka, his affidavit says they lose those, but they can restore them over here. Again, not for free. And that's the notion of the Armstrong test, which is that public burden should be borne by the public and not by a private landowner. So they want to have bike lanes, fine. They want to curb this roadway to reduce conflict points into the right of way, fine. But it's an imposition on this property owner, and they have to pay for it. And that's what the Texas Constitution says, unadorned, undiluted by a material and substantial impairment of access case. This court has said that taking into consideration the existing use of the property, that if you come in and you wipe out an entire row of the parking, then you have materially and substantially impaired their access. And so I think that for purposes of this case, you're bound by Latinas, but there's lots of Supreme Court authority for the proposition that, for example, the loss of a parking space or the need to have to, because of the taking, you have to relocate a detention pond, or because of a taking, you have to relocate some building sites. Centennial Morgan says that's compensable.
So remind us of where the evidence is of all this.
Well, the evidence at this stage is not there. I mean, the evidence is undisputed, and so you can look at Mr. Havlicek's affidavit and the concessions and the pictures and see exactly that everything we're saying is true. But what is more true is the Miranda standard says, but before you get to that, Miranda's standard, and have it here, and I'll read it. If a plea to the jurisdiction challenges the existence of jurisdictional facts, we consider relevant evidence. So step one, the plea must challenge the existence of jurisdictional facts. The plea doesn't. It does attach some evidence. I think the evidence that it adduces is not super contested, but in any event, first thing they had to do to get to that was to challenge jurisdictional facts. If there are no challenge to jurisdictional facts, you don't consider the evidence. You consider the pleadings as true or in the favor of the pleader. And if you wanted to do a challenge to jurisdictional facts, there have to be the procedural protections. And the last little bit of Justice Christopher's opinion says that would have to happen with competing motions for summary judgment, which we don't have. But we don't have a summary judgment here either. We didn't get 21 days. We didn't get the Wood Oil process, which is an evidentiary hearing. We have a challenge to the pleading very plainly. If you read the plea of the jurisdiction, it simply does not challenge any jurisdictional fact. Will we have to prove our case? Yes, we will. At this stage, no. And they knew that. They pivoted on that because of the Latinas opinion, from which I do not believe they can escape. Thank you for your consideration.
All right, thank you, counsel. 14-24-00869 is submitted, and we're adjourned.